Blog Talk Radio.
Welcome to Family Law Talk.
Family Law Talk.
Presented by Kirk Stange of Stange Law Firm, PC. Stange Law Firm is a family law firm with offices in Missouri and Illinois. Now, here's your host, Kirk Stange.
Welcome to Family Law Talk. We have an interesting topic today. The topic is tracing assets in divorce matters. This is an interesting topic that definitely comes up in a lot of divorce cases out there. As a follow-up to the episode today, you can go to familylawheadquarters.com. We've got an article on this topic as well, dated July 5th, 2015, and the title of the article is The Importance of Tracing Assets in Family Law Cases. So as a follow-up to the episode, you can go to familylawheadquarters.com, and you can read this blog article on this topic. But let's jump into the topic itself and go into really the intricacies of it. At the end of the day, in a divorce or family law matter, the court has to divide all marital property and debt that the parties bring in into the marriage or they accumulate during the marriage in a just manner. So Missouri and Illinois are both what are called equitable division states, and the statutes in both states indicate that the judge is to divide the marital property and debt in a just manner when considering all relevant factors. And so both the Missouri statute and the Illinois statute go through different intricate factors that the court is to look at in dividing marital property and marital debt in a just manner. As it relates to money and assets brought into the marriage, this is typically called separate assets. And so in a divorce case, all property accumulated during the marriage is presumed marital property, except certain assets are deemed separate property. So take assets brought into the marriage. So assets that an individual had before marriage, and then gifts to them and inheritance to them, all of these items would be deemed separate assets. But there's a common solution or a common scenario that comes into play in a lot of these cases, which oftentimes muddles this issue. So take, for example, somebody who has a 401k, and they had that 401k before they were married, and they were contributing to it, and they were building up a nest egg in this 401k, for example. And then let's say after they get married, they can continue to contribute to the 401k after the marriage. The dilemma in this situation is that part of that money, that 401k, would then presumably be separate property because it was accumulated accumulated before the marriage itself. So somebody's labor before they're married, that's their separate property. On the other hand, money that's put in after the fact, after the parties were married, that's marital property. And so what happens is marital property, money earned after the marriage commences, gets commingled with separate property, which is money that was obtained prior to the marriage itself. And so it all gets commingled together in one big pot, if you will. And that is, in essence, the dilemma. Now, there's other situations where this could come into play as well, and there's probably a litany of examples we could go through where this could be the case. It can happen with other assets besides 401ks. It could be bank accounts. It could be investment accounts. It could be an IRA. It could be that somebody owned a house before marriage, and then after marriage, marital funds are being used to pay the mortgage, for example, and then maybe the equity in the house increases after the marriage. So certainly there was some equity built up before the marriage, but after the marriage, additional equity was built up in that house. And this is particularly true in cases, or particularly relevant, if you will, in cases where the title then is not put in the new spouse's name. So the house was owned before marriage by one spouse. The other spouse then contributes after the marriage. The value of that house keeps going up, but the new spouse's name isn't put on the property itself. And so this is kind of the dilemma. For the individual who maybe owned the 401k, going back to that example before marriage, one of the things they often want to have the court do in a divorce case is, in essence, trace out their separate assets. So they want the court to say, this is what the one spouse had built up in this 401k before marriage, and that balance should be set aside to the spouse that built that up prior to marriage, owned it before marriage, if you will, and then only the increase on that 401k is marital and should be divided. And so what we're talking about in this situation is an individual really asking the court to trace out what somebody's separate property was so that separate property comes off the top to that spouse, and then the court takes that marital portion, if you will, and divides it in a just manner. So just to give you a hypothetical, let's say 401k had $60,000 in prior to the marriage, and that's all funds that were accumulated prior to the marriage itself. And then say the 401k is now worth $120,000 at the time of divorce. And so what you're talking about is one spouse inherently arguing that $60,000 should come off the top, and then only the additional $60,000 is what should be divided by the court in a just manner. So that $60,000 comes in play, but the $60,000 is off the top. Well, here's the deal in essence. Sometimes it's easy to trace out these separate assets simply by looking at bank statements, trying to get 401k statements, if you will, at the date of the marriage to trace that out. But sometimes this can be particularly complex. Sometimes it's not as easy as getting these statements. Certainly, the longer term of the marriage, the more complex this becomes. And then in circumstances where you're dealing with interest, for example, or dividends or something like that, this can be much more complex and much more hairy. And the general rule is this, is that in a divorce, if one party doesn't trace out that separate assets, in other words, if they don't present evidence to the court to show what they had prior to the marriage by clear and convincing evidence, then the court is to presume it marital. So take that $120,000 example. Somebody comes into court in a divorce, there's $120,000 in, they think $60,000 was what they had before marriage. They have a duty to prove that by clear and convincing evidence. If they don't do that, the court could presume that whole $120,000 to be marital property in that 401k and find that the one spouse didn't rebut that presumption by clear and convincing evidence. In other words, they didn't trace that out. So tracing can happen through the accumulation of statements, but oftentimes tracing is best had or takes place, if you will, if an expert comes in, a tracing expert. So in a lot of these cases, a forensic accountant, what they do is they come in into the case. They're retained by one of the spouses in a divorce case itself. They obtain the statements, and they do calculations, if you will. They'll look at interest and dividends and various things like that. And then what they do is come into court with a report, and they render an opinion to the court. In other words, they'll come in and testify as to the portion that they think is separate property, and they trace that out, and then they will differentiate that from the portion they think is marital property. And in a lot of cases, in a divorce, it's important to have a tracing expert like this. It can really help move the needle in the case, can help ensure that a party is able to trace out their separate assets. And certainly the more money that's at stake, the more advantageous it can be in some cases for a forensic accountant to be retained as a tracing expert to help trace those assets out. Oftentimes parties just want to come in a conclusory manner and testify based on their recollection on what they believe to be the case, and there's not an expert to back up what they're saying. The statements aren't obtained going back in time. And again, this can be particularly tough if the marriage is a long-term marriage, so you're talking about going back and getting statements 10 or 20 years earlier to try to trace this stuff out. It can be messy in a lot of cases, and of course a lot of parties don't want to incur the cost in terms of having a forensic accountant come in to trace out these assets. But in some cases it's absolutely necessary, especially, like I said, if we're talking about accounts with value. Certainly in a lot of cases the cost of the tracing expert is well worth it when you look at the dollar figures that are in play in the case. And so, for the listeners out there, something to think about, something to consider, definitely something to talk about with a family law attorney if you're going through a divorce case and there's a belief that you have separate assets brought into the marriage and you want to trace those out because you believe you earned that prior to the marriage and that those assets ought to be yours. So again, that's a topic. Definitely an interesting topic. As a follow-up to the episode today, go to familylawheadquarters.com. Check out the article titled The Importance of Tracing Assets in Family Law Cases. Definitely an important topic. Definitely one that folks want to think about if they're going through a divorce matter and they believe that they've brought assets into the marriage, and they want to ensure that the separate property that they had coming into it is effectively traced out. So again, thanks to all the listeners for tuning in. That's the topic here today. We'll see you next time on Family Law Talk with Stange Law Firm. Thank you very much.
Thank you for listening to Family Law Talk. Family Law Talk with Kirk Stange. Visit StangeLawFirm.com for more about today's topic or to put Stange Law Firm to work for your family today. The choice of a lawyer is an important decision that should not be based solely upon advertisements. Neither the Supreme Court of Missouri or Illinois reviews or approves certifying organizations or specialist designations. The information you obtain on this podcast is not, nor is it intended to be legal advice. You should contact an attorney for advice regarding your individual situation. We invite you to contact us and welcome your calls, letters, and electronic mail. Contacting us does not create an attorney-client relationship. Please do not send any confidential information to us until such time as an attorney-client relationship has been established. And finally, past results afford no guarantee of future results, and every case is different and must be judged on its own merits.
Kirk Stange is responsible for the content. Principal place of business, 1750 South Brentwood Boulevard, Suite 401, St. Louis, Missouri, 63144.
How's your money feeling? It's about to feel happier with a certificate from Happy Money's partner, Michigan State University Federal Credit Union. Elevate and increase your savings with 18-month terms and only a $500 minimum. And the happiest part? MSU FCU certificates yield 4.5% APY annual percentage yield. Now that's a happier side of money. Elevate your savings. Go to happymoney.com/MSUFCU. That's MSUFCU. Funds insured up to $250,000 by NCUA. The APY is accurate as of the 12/1/2023 dividend declaration date. Early withdrawal penalties do apply. Fees may reduce earnings on the account. Any monthly withdrawals or transfers reduce earnings.
The holidays start here at Kroger with a variety of options to celebrate traditions old and new. You could do a classic herb-roasted turkey or spice it up and make turkey tacos. Serve up a go-to shrimp cocktail, or use Simple Truth wild-caught shrimp for your first Cajun risotto. Make creamy mac and cheese, or a spinach artichoke fondue from our selection of Murray's cheese. No matter how you shop, Kroger has all the freshest ingredients to embrace all your holiday traditions. Kroger, fresh for everyone.